Welcome to the EU office in San Francisco. Welcome to the first edition 2026 of our Brussels to the Bay policy events. Very happy to see the full room on 1 Post Street, 24th floor. And welcome to everyone online. I'll try to stay in the field of vision. My name is Joanna Smolinska. I'm the deputy of the EU office in San Francisco. The office established in 2022, and it's since then that we've been running these events. Brussels to the Bay is a series of policy briefs where we gather European and American speakers to discuss issues about technology legislation, investments, projects, issues that are on everyone's or on many minds these days. And today we're going to talk about opening digital markets for innovation. Before we start with our panel of speakers, I will run through a number of, I wanted to basically help you understand what they'll be talking about during the panel discussion. Because when we were preparing this event, I realized that there are many antitrust decisions, that there is the EU DMA legislation that has been enforced for over a year. And some of you might not be really familiar with some terms. And so we will have a short presentation that we can start with about how the EU is, what's the EU policy toolbox for opening digital markets for innovation. And I'll bring some elements that are similar to what is happening also in the US. And then that will take us 5-10 minutes, and then we will kick off the panel discussion. Next. So openness and contestability of digital markets are not a given. Yesterday, I participated to an antitrust conference in Palo Alto that is called Concurrences. And many of the speakers, it was heavily focused on antitrust. And many speakers were saying that the antitrust toolbox still applies in a similar way to different sectors, like the digital, and that the digital sector was not really different from the financial sector or energy sector, where we see many powerful players. I would disagree with that because the digital sector, and I'm bringing just a few no-brainer elements to characterize those digital markets. And these are network effects. The more users there are on platforms, the more value they get, and the more concentrated they get. Scale and the amount of data, the troves of data that they have access to, contribute to them gaining more power. And the economic power, if you just look at market caps, the big tech digital companies are in the top 10 of the richest companies in the world. Next. And so, without going into details too much, I'm not going to give an overview of the whole legal framework, but I wanted to bring a few elements to situate the conversation into. So the legal framework that applies to digital markets in the EU and in the US is, in the EU, we have a traditional competition law, antitrust law that is enshrined in the Treaty for the function of the European Union, and we also have an ex ante regulation. That's a different, a little bit of a different element with the situation in the US, where digital markets are governed by the federal antitrust law and state antitrust law that is enforced by FTC, DOJ at the federal level, and attorneys general also at the state level have a role to play. Now, the examples that I want to bring when it comes to DMA, and some of them are also present in the antitrust decisions, are specifically relating to the pro-innovation angle of this of these government structures. So under the DMA, at the next slide, I'll just quickly show you which are the biggest companies that have been designated as gatekeepers. The DMA only applies to them. DMA does not apply to the whole spectrum of the digital services like the DSA does, Digital Services Act. So that's a big difference. There are many other differences. But what DMA requires, and what since the time that the DMA has been adopted in 2022, started applying in 2023, and is in force when it comes to the designated gatekeepers since March 2024, we see changes happening not only because of the enforcement that the European Commission is running, but also because of the mere fact that this regulation has been put forward. It took a lot of political will to come up with an ex-ante regulation that the DMA is. Some of those requirements and changes already happening are when it comes to interoperability. And I'm not going to talk more about that because we have a whole panel where we bring practitioners who also from representing American companies that will be able to talk to these points. So gatekeepers have to make sure that solutions of third parties can interoperate with their operating systems and on their devices. When it comes to data portability, interesting fact is that Instagram, TikTok, and Facebook have started introducing specific APIs for easier data portability. So you can port easier in Europe your videos, your photos, even what you like from Amazon. You can port your whole search and buying history. When it comes to sideloading, that's a big one. Sideloading basically means that there can be alternative app stores, and that you can download apps from outside the existing app stores and still use them via the mobile devices that you own in the EU. There's a whole list of those where I put asterisks is where the US antitrust decisions came up with similar concerns and similar suggestions for solutions, which we will see a little bit later. So DMA as a legal framework is a law that helps smaller companies on the basis of the objectives that the DMA legislators have established for themselves, for the law, such as fairness, more openness, fair competition, leveling playing field, is for new and existing competitors to have a fair shot at the businesses and at the user bases that exist in the EU. Next one. These are the gatekeepers, so that when we speak about gatekeepers, we speak about these 7 companies. But gatekeepers as such, they're not designated for their whole of operations. They're designated for the core platform, what we call under DMA core platform services that they run, and the conditions for being designated as a gatekeeper are very precisely defined in the DMA. The core platform service run by a company has to operate in at least 3 EU member states to give it an internal market angle, because the legal basis for DMA is internal market of the European Union. A second condition is defined on the basis of the revenue threshold in the EU. It has to be more than 7.5 billion euros of a turnover, or 75 billion euros of global market cap. And then the third or the second condition, but one of the 3 thresholds, is the number of users. So under the Digital Services Act, you might know the number of monthly users for being designated as a very large online platform or search engine is 45 million monthly users in the EU average. And we took that same number for the DMA, but we added, because we're talking about 2-sided markets in the DMA, we're talking about connecting those companies that connect business users with end users. And so we added an additional condition, which is 10,000 business users. So all these three conditions have to apply together, and these are the core platform services that are in the scope of the DMA currently. Coming up, another 2 minutes, and then we go into the panel. I just wanted to show you what you can see on your mobile devices in the EU when it comes to, oh, okay, well, this one. So one of the requirements under DMA is that gatekeepers cannot just combine personal data across the core platform services that they operate. So in the EU, on your mobile phone, you are the one who will decide who can click on those for them to be linked. This is a specific example for Google. And then, so you have to give an explicit consent for your data to be combined or not combined for Google to be able to use them together. Next one is about choice screens. This is when you open your mobile devices in the EU, you don't only have one web browser or search engine, but you can basically choose at the moment of installing the software, the default web browser that you want to use, and you can change it anytime. This is a summary of, so on the slides before, I showed you how, just the two examples on how DMA opens opportunities for us as end users. And you might think, why would I want to not have my default? It's so easy. I just open my phone, default is there. Why do I have to choose? Okay, it might seem like a nuisance, but when you think about innovation in the longer term, when you think about actors who might want to enter this business space, there are lots of opportunities that these online platforms create. Our behavior, our user behavior that is or is not allowed, creates opportunities for other businesses, opens those walled gardens or not. And so just a few examples that I already mentioned: alternative search engines and browsers. On the choice screens, new interoperability solutions and opportunities. In the EU, you can, Apple, after regulatory dialogue, very constructive regulatory dialogue with the European Commission, came up with solutions for third-party devices to connect in a seamless way with, for example, with Apple Watches. So your earbuds don't have to be necessarily Apple earbuds; they can be whatever other brand, or your Garmin can connect seamlessly with your phone or your Strava application. When it comes to steering to alternative offers, this is a very interesting requirement and a change that we see on the market already as well, meaning that before or in other places of the world, gatekeepers would sometimes tell business users that constrain business users to keep their best offer, which is what we call price parity clause or most favored nation clause. They would ask those business users to reserve it for the platform that they were using, and under the DMA, they cannot do that anymore. So if you're a hotel or a car rental present on one of the intermediaries, you can give your best offer there, but you can also give your best offer on your website whilst still connecting with users through the gatekeeper core platform service. When it comes to alternative app distribution channels, some of you may have heard about Epic Games versus Apple here in the US. It's about app developers being able to offer their services outside of the app stores, and for them to be able to also function with alternative payment solutions that would not only be necessarily used on the app stores. Next, and this is just to illustrate, we can go quickly through them. This might pop up during the discussion. There has been a number of enforcement decisions under the DSA in the last year, so enforcement continues. in a very constructive way in a regulatory dialogue between gatekeepers and the regulator and the European Commission. And Meta consent or pay model is such one example, because after the non-compliance decision, the Meta has committed last December before Christmas to coming up with to give an effective choice for to EU users, so that they don't have to consent to sharing all their personal data, but they can either share all their personal data and have a fully personalized advertising, or they can opt to share less of their personal data for more limited personalized advertising, instead of being forced to pay for the version of Meta that would use less of their personal data. Apple steering terms in the App Store. This is the non-compliant decision is out, and discussions are ongoing. Next. When it comes to the choice screen for Safari, again, investigation by the European Commission closed after Apple implemented those changes that I presented on the previous slides. We can go quickly through the rest of them, and I'll invite the speakers to the panel. There are antitrust decisions as well, but I won't take more time. Google Ad Tech decision is what one of our speakers can speak to, because there are very interesting similarities with the antitrust decisions that have taken place in the US as well. I'll stop here, and I'll invite the panel to come up to the stage. And as they come up, I'll introduce the moderator, Mike Masnick. He's the one who runs Tech Dirt blog and Control Alt Speech podcast. Thank you so much for moderating today. Carlota Reyners-Fontana, who is our guest from Brussels. She works at the European Commission. She's the director for antitrust for the IT, communications, and media sectors at DG Competition. She used to work with us, with Gerard and me, at the DG Connect at the European Commission when we were still working in Brussels. Then we have Aaron Shore, who is the Chief Legal Officer of Yelp. Thank you for being here. And our own Gerard de Graaf, Senior Envoy from the EU to the US for Digital, and the head of the EU office in San Francisco. So take it away, Mike. Thank you so much.
Well, first of all, thank you so much for being here. Thank you for inviting me to moderate this. We'll have this. So I'm hoping it's going to be something of an open conversation. We have the two European representatives. We have one platform representative who's not a gatekeeper. We have no gatekeeper representatives. I am not normally someone who's representing a gatekeeper, but I will sometimes have some questions that maybe hopefully we'll try and get across. Well, but some of the gatekeepers say this or whatever, and we can hopefully get the conversation. Also, I take my role as moderator seriously, and that I will moderate, which is that if somebody starts talking too long, hopefully I might jump in and move on to somebody else and have this conversation. But to get started, the thing that I wanted to do is have a little bit of scene setting, definition setting. We're talking about this idea of open innovation. So I just wanted to get very briefly from each of the panelists, and we can go. I'm switching to the microphone. Okay. The microphone in my pocket is not working, or okay, it will be fixed. In the meantime, I will go and I will hand the microphone down person to person. And I just want a very, very brief summary of what you think success means for an open market for innovation in the EU. What does it look like to you? Because it's sort of a broad concept of, oh, we want open market for innovation. So just a very quick to start, what does that mean to you as a concept?
Thanks very much, Mike, and thanks, Gerard, Joanna, the office for the invitation, and everyone to be here. It's really a pleasure. As he said, I'm coming from Europe, so I'm relatively jet lagged, worse today than yesterday. So I say this as a caveat already as a start. And also just to remind that what I say here is my personal opinion and not representing the European Commission. So I was trying a bit to prepare for this event, but it was completely a bit spontaneous, as Mike has his questions that he hasn't raised and shared with us. From my point of view, as Joanna explained, I work in DG Com, so we are enforcing competition rules, which means antitrust mergers in this sector, IT, communications, media. So when I think of what it means for digital markets to work, for me, it means that there is competition, because competition is what ensures that, that there is a variety of offers, that there is good quality, that there are good prices. And as actually even Draghi has recently reminded in his report, so Draghi did this report for competitiveness for the president of the European Commission, competition is what drives investments and innovation. And if there is a sector where there is a lot of innovation and you want to make sure that that continues, this is one of the sectors. So for us at DG Competition, what we are very closely monitoring markets, because we are concerned in a market where there is enormous technological development, but also companies who are extremely big, which have really big pockets, which have potentially entrenched position in certain markets, that they can abuse that position to close competition or to close innovation, to close new entrants. No, they can reserve inputs for themselves. They can give preferential treatment to their services. They can have access to a lot of data that competitors do not have. So is all this what we are looking at, and that we could be concerned. But if people would have access to inputs, would have access to distribution channels, and we can speak about it later, then you have competition, and then you have markets which are functioning.
Great, thank you very much, and thanks for having me here. So I'm at Yelp, which hopefully folks know what that is, but we are a local search and discovery site that allows people to connect with great local businesses. So whether you're looking for a pediatrician, a pizza, or a plumber, hopefully you can come to Yelp and find what you're looking for. Now, I've been at Yelp for 15 years, which is a lifetime in tech. And around the time that I started, we were launching in Europe. We launched in UK in 2009, France in 2010, and expanded throughout Europe over the next few years, and even dozens of countries internationally. But in 2016, we actually withdrew. And we withdrew our sales and marketing efforts from Europe. And why did we do that? Well, we did that because of Google, which is the dominant platform for general search in Europe, even more dominant than it is here in the United States and most European countries. And Google self-preferencing, people are perhaps familiar with this. If you search for a local business on Google, you get Google's own local content upfront, filling up the page, especially on mobile, fueled by their own local reviews, their own local photos from their user base that they've submitted. And this is a separate algorithm from their organic algorithm, which gives you the organic results. So it's not really showing you what Google decides is necessarily best. It's showing you what's best for Google, the content from Google itself. So on that basis, we were unfortunately unable to get the network effects that would help us grow further in Europe with Drew. So when you ask what innovation looks like, I completely agree, competition. But for us in particular, it's addressing self-preferencing. So we're big advocates globally of regimes that both create ways that can be addressed, and rigorous enforcement. So we have been participants in the workshops related to enforcement of DMA against Google under Section 6.5, which is under Article 6.5, which is the provision that addresses self-preferencing. And we hope to continue to see that sort of rigorous enforcement, as well as seeing other countries worldwide pick up on that as well.
Thank you. Good afternoon. I mean, I should maybe thank you for putting me on the panel. I did not put myself on the panel, if anybody thinks that is the way it's happened, but And I'm probably on the panel because I had a role back in Brussels in conceiving and then subsequently negotiating the DMA and the DSA as well. I mean, keep that to yourself, so that for political reasons, and working very closely with our colleagues in DG Competition. So, I mean, I have probably a bit of insight on like, well, what was behind and what motivated us. But your question, Mike, I mean, there's an interesting book about startups, if you want to know more about like that whole kind of ecosystem and what VCs particularly are looking at, and by Peter Thiel. It's called From Zero to One. It's been a book that's been around for a long time. And the key tenet in that book is like, well, try to become a monopolist. I mean, if you can kind of, I mean, the competition is not necessarily something that we fancy. We don't want to compete. If we can get into a market where we can set the rules and we can dominate, that's a very attractive value proposition, not just for VCs, but also for companies. So this idea, and of course, nowadays in Silicon Valley, and you look at AI and across the world, there's a lot of competition. So the argument is, look at the tech, and it's so dynamic, and look at the last 3 years in AI, and that's true. But in essence, I mean, if companies get an opportunity to avoid competition, then they will. And we have seen, and for the reasons, and again, that's like, I mean, in digital markets, I mean, it's the network effect, is the scaling up. I mean, the marginal cost of adding further customers, you can very quickly build up a quite dominant position, as we have seen. And so what we were concerned about is kind of that, but also concerned about like those who are depending on access to their customers and that have to go through these gatekeepers. I mean, if you are an app developer, it's nice to be an app developer, but if you don't have really good access to like the apps or fair conditions of access to an app store or Google Play, or if you're just a company, I mean, if you look at the marketplace like Amazon, I mean, more than half of Amazon is third-party seller turnover. So if you want to reach your customer, I mean, there's no way around Amazon, or in Europe, there's no way. I mean, you can't say, well, I'm not going to work with Amazon, but then you miss out like half or even more, or 60, 70% of your potential users. So what does success look like is where everybody can have a fair shot at getting, like if you develop like the next generation of mousetraps, you can get a fair share of like the mousetrap market. And you're not going to be like hindered or kind of unfairly disadvantaged because of self-preferencing, as we heard Aaron talk about, or kind of certain very difficult conditions that some of the gatekeepers implement. I mean, walled gardens. I mean, I have like iPhone, I have like iPad, I have iWatch, I mean, I have AirPods. But if you are a different provider, I mean, all these like the convenience that you have, automatic connection with your watch, automatic connection with your AirPods. I mean, just you can kind of, I mean, I get messages like on my iWatch. Those facilities are not available, at least not before the DMA, to competitors who want to get into this market. And so why should these kind of devices just work for like the gatekeeper's own products and not work for products that come from the competitors? So this is where the European Union has said, we want to open up that walled garden. There need to be opportunities to compete and therefore to innovate, maybe to come with a better watch or better AirPods or connected glasses in the future, etc. So ultimately, it comes down to fairness and to getting like better user experiences, and that's what the DMA is about. It's also, of course, what antitrust is about, and so no surprise if you intervene into a business model of a company that has, in a way, been shielded from competition, that you will get some pushback, and that's what like we've seen, of course, about I mean over the last couple of years or months. So that'd be surprising if that did not happen. If there was no pushback, then probably what we were trying to do with the DMA would not succeed. So it's actually quite good that some companies don't like the DMA because it shows that it's working.
So, so I think competition being sort of the through line here, one of the questions that comes up, and this is sort of traditionally, in an idealized sense, sort of European approach versus US approach to thinking through things like that. And US generally is, looks at things like antitrust, which might step in and maybe block an acquisition, but more likely break up a company if it decides that it's a monopoly. DMA, of course, is much more proactive in terms of setting up certain rules to try and enforce this. The question, this comes up in lots of different contexts, is that when you have a set of regulations that companies have to live up to in order to enable competition, does it always enable competition, or does it sometimes create sort of regulatory hurdles that actually lock in the companies that are able to comply? Are you creating a compliance hurdle that then limits the ability for smaller companies to compete and jump in? I might want to start with Aaron on that, being a company, but then I'd also love to get the EU perspective as well.
Sure. I mean, I think that's certainly a risk when you look at any legislative regime on paper, but it really comes down to the enforcement and the enforcers really looking at all the angles to ensure that doesn't happen and that it doesn't run counter to the purpose. So for DMA, for example, it holds great promise in creating competitive markets and providing great experiences for consumers and for entrepreneurs, a better ecosystem. And our experience shows, though, that this enforcement, this really needs to be strong, and you have to look out for half measures and I'd say really imaginative forms of non-compliance. When Google was first circulating mocks related to its proposed compliance with Article 6.5 of DMA, it really was still self-referencing. It showed its content with a lot of photos. There was a module for rivals, but they were all lumped together. And it was pretty far down the page. And we at Yelp actually ran click tests on this proposed mock. This was around, this went live actually in March of 2024. So we compared it to a baseline of late 2023. And we found that the mocks that Google, or the reality that Google by that point had implemented in Europe, was actually giving it 73% of the clicks. And this was against the baseline, which was only 55% of the clicks. So it seemed like they were leveraging the enforcement to actually increase their share of the clicks on the local search results. So that just illustrates that, as you said, companies will not only perhaps avoid compliance and try to avoid competition, but they might actually try to use the asymmetrical information distribution, and that they know more, that they have all these levers to pull, and that the enforcers might not be clued into everything that they're doing to actually increase their market share.
I think your question, Mike, like, is regulation actually something that companies, in particular big companies, can use to shield themselves from competition? And I think that it requires a nuanced answer. I think you can't just say yes or no. I mean, in some cases, possibly. I mean, I can think of like that argument being made, for example, for the GDPR. Yeah. The GDPR being a fundamental rights framework. I mean, we don't distinguish in terms of the obligations between very big companies like Google and the bakery store on the corner. I mean, a fundamental right is indivisible. I mean, you have to honor it, you have to respect it. And so there you have, of course, these very big companies that have like also departments with full of lawyers. And so it's easier for them to deal with that than like a small bakery store or a startup that is just starting. And the last person, at least the first person they don't want to hire is a lawyer. They want to hire maybe an AI engineer, etc. So there, I think you can make that case. And we need to think about that. But if you look at other kind of regulations, I mean, I was actively involved in DSA, for example. This is an asymmetric relationship. It's a risk-based regulation. So where the risks are higher, and you are under more obligations. And that's typically true for large companies because their reach is much greater. So if you look at the DSA, if you're a very large online platform, I mean, you have like the full panoply of the obligations. If you're a small company or you're like part of like what I would call the basement of the internet, like content delivery networks or domain names, you have very limited obligations. So we tailor it to, like in that case, actually, the bigger companies have greater obligations. If you look at the DMA, I mean, you saw the scope. There's 7 companies. So the obligations that flow from the DMA are only applicable to these 7 companies. No other company is under the call it the weight of the DMA. So to argue that in that case we are putting like burdens on other companies, no, we are not. We have clearly defined the scope on the basis of a thorough problem analysis. So I think it requires a bit of a case by case assessment. I think the EU has become more aware and concerned about like avoiding unnecessary, I mean, the whole like simplification drive that's happening at the moment. For example, also with the EU AI Act, one of the key measures that is being kind of put into what we call an omnibus regulation is to remove, I mean, the small businesses and the mid-cap businesses, I mean, we remove obligations like reporting administrative burdens on them. Just to conclude, I mean, the worst for small companies is a fragmented regulatory environment. So maybe regulation is not what companies are necessarily always looking for, but if you have regulation in EU with 27 member states, that is different from like one member state to the next, that's absolutely making it impossible for companies to grow. And one of the reasons I get often this question, like, why don't you have more big internet companies or tech companies in the European Union? And there are many reasons for that, and access to capital and maybe risk-taking. But certainly one of the reasons is it's just difficult to grow in the European Union, because if you're successful like in Germany or in Belgium or the Netherlands, you expand. First question you have to ask yourself, and what about the regulatory environment? Take a company like Spotify. One of our crown jewels, we're all very proud of, and I'm sure many of you are using Spotify. How did Spotify grow? It started in the Nordics, Sweden, went to Finland, went to kind of Denmark, stopped expanding in Europe, came to the US, got scale, came back, and then completed its coverage around the European Union. They could not scale in Europe. So is it helping or hindering companies? The thing that we really need to avoid, and it's also like what's happening a little bit in this country now with like all this state legislation that we see emerging around AI, is a fragmented regulatory landscape, because that's absolutely stifling innovation. If we have one set of rules, which we have increasingly in the European Union, that like, I mean, okay, it's rules to make sure it's proportionate, we have to make sure it's effective, to make sure it's implemented and enforced, but at least you have access to a market of 450 million users on the basis of one set of rules, not 27 or sometimes in this country now like 30, 35 states that have implemented AI regulation.
Let me just do a really quick follow-up on that. I see the difference between, with the DMA, it has a small list of gatekeepers. So you're not creating regulatory burdens on smaller companies. But is there a different kind of risk with something like that, where you've is there a possibility, and feel free to push back on this, but is there a possibility that you've locked in those companies as the gatekeepers, so that yes, there may be more competition within those marketplaces, within those platforms and on those platforms, but that limits the ability for someone new to take a different approach that might, overtake one of those gatekeepers in the first place?
Yeah, I mean, we don't know. I mean, that's of course, it's not been the objective. I mean, we don't want to lock in a situation. We want to bring more dynamism. We want to bring change. I mean, actually, if some of the gatekeepers stop being gatekeepers, that might be a good thing, because it does mean that there's competition in the market, and therefore the powers that a gatekeeper has to set the conditions for like that market, has disappeared. So the grounds for actually policy and regulatory intervention has disappeared. That would be a good outcome if that happened. I mean, is that going to happen? We don't know. But at least what we're trying to achieve now is more opportunities for the potential challengers to dislodge the position of the gatekeeper. I mean, are they going to be successful? They will have to work extremely hard. They will have to come up with better solutions. They will have to convince users to switch, which is also from one like platform to another. But that opportunity is much greater now with the DMA than it was before. And I think the advantage also of the DMA, I mean, I'm not kind of here as the salesperson of the DMA, but you heard like Aaron's experience. It also provides kind of regulatory clarity. I mean, again, nothing against antitrust. It's an incredibly important and effective policy tool. But here in the DMA, this is ex ante. it's an internal market regulation. It's not a competition policy regulation, even though it's inspired by like experience that we've had over the years with the enforcement of competition policy. It basically says, if you operate in the European Union, this is what you must not do, the do's and the don'ts. This is what you have to do, particularly around interoperability. This is what you are not allowed to do. You can't self-preference anymore. And so to put that baseline in place creates also like a legal certainty. Whereas with, take Google, you talked about Google and Google Shopping, etc. These cases have been running. I remember, having worked in the European Commission, companies like Yelp and others coming to see us, map developing companies and saying it's all terrible and kind of we can't compete, we're not visible anymore. Where are these companies now? What do you think happened to these companies? They all died. They didn't survive because it took too long. They count like 2, 3, 4, 5, or 8 years in the case of Google Shopping. Companies that benefit from a decision, they no longer exist. So that's like the sadness or the tragedy of competition policy. Sometimes it's like for the successors, the others are dead. So everybody that comes later might benefit from it, but the ones that like were in the market before have often left the market because they had no chance to compete. And with the DMA, that's now kind of, we put a framework in place. So these are the rules. You want to play football, these are the rules. I'm not going to invent the rules on a case-by-case basis or so. That's the difference.
Yeah, no, maybe a few reactions to this, but also your question, which doesn't equally apply to antitrust, but maybe I can bring a bit of ideas. No, just to make even crystal clear on your question, that gatekeepers are defined as per certain objective criteria that Joanna described. And then if all of a sudden they don't meet those criteria anymore, they are undesignated. No, but that should mean good news, that therefore they are not anymore what the name says, a gatekeeper. And therefore, if you're not that, then you can act in a different manner. So that brings flexibility, but it's only because you impose on those when they are gatekeepers obligations that they can allow smallers to then thrive and potentially then compete. And that's not, I don't see really the regulatory burden there also. Maybe on the antitrust side, so yeah, one cannot say antitrust impose a burden, since what we do is we investigate ex post a practice that a company might have done. And generally, in the sector, we look at abuse of dominant position. So this already tells its dominant position, which is a concept which is different than gatekeepers, which means market power. You are dominant, you are the bigger. And therefore, you can do certain things that other players cannot do. What we are very keen is when we intervene and we say, okay, this is wrongdoing, you have to stop this, or we can impose it. Then, of course, we want to make sure that this works, in particular also to ensure that competitors can compete. And therefore, it's very important when we use commitments procedures. Those are procedures where we're not going to go confrontational to the company, impose a fine and prohibit, but they agree actually to cooperate. And then we can frame a remedy that comes from them, so also in cooperation with them, but then we market test to make sure that it's helpful for the competitors. And then we can hear the competitors telling exactly, okay, is this interoperability solution functioning or not? Is this the way I want access? Is this the price that I need differential to? Okay, so that's important. We had a case, or for example, when we impose remedies after a prohibition, let me take an example. November 24, we went against Facebook, so Meta, for having tied together its Facebook social media to its marketplace. Just to note that Facebook marketplace, it's not designated in DMA, and there were tyings. What that meant, that all the users of Facebook, if they wanted to buy a car, shoes, or whatever, they would see a little tab saying Facebook Marketplace. Oh, great, I click there and I have plenty of products. So they were accessing Facebook Marketplace, immediately accessed all the Facebook users to sell products. And therefore, they were attracting a lot of advertising there, which is their model. When we adopted it, so they did that. And then secondly, they were having agreements with the advertisers where they could use the data of their competitors actually to improve their products and to improve advertising in their Facebook marketplace app. When we prohibited the practices, we said, okay, you have to untie. Now, untying is a very difficult thing, and we have had cases in the past where we just said, UCs and desist, we were not defining anything. Microsoft was one of the first cases. It never really worked because they basically did a sort of something as if they were untying. Now we were a bit more prescriptive, and we were telling them, well, you really need to give a choice. So either you do a standalone app, Facebook Marketplace, anyone can access it so that it competes on equal terms with others. Or if you offer a tab in your Facebook, then you need to offer a choice, a bit like the choice screen you showed, Joanna. And now what we do is Facebook has proposed a solution and we market it. So we are monitoring and we are trying to see if there is, it's not exactly what we had proposed, so we are checking what they're doing. And I think that goes for the, it's not burden, but just to ensure that solutions also work, because otherwise antitrust, I mean, doesn't really solve the issue.
Yeah, I don't know. So I think, to me, the story of tech policy in general always is about trade-offs, and different approaches often conflict in terms of goals and setup. I mean, you talked earlier about the GDPR and sort of how that came about, and how there have been some complaints about maybe that harms smaller companies, but because of the rights framework that went into it. So with every approach, I think there are some trade-offs. How legitimate they are depends on where you sit and what you say. One of the things that we've heard about the DMA in particular and things around interoperability is that they raise security concerns. You're now forcing companies to open up access to certain data. How do you make sure that that data is kept private or protected? And in fact, you can see some ways in which the requirements for openness and interoperability and data portability could potentially run into questions around the GDPR. How do you balance these different factors and these different trade-offs to make sure that you're figuring out a way to balance these and not overweighting something in one direction or another?
I mean, you're right, Mike. I mean, we wish the world was simple and there were never any trade-offs and you could just do this and it would all work perfectly. I mean, indeed, there are issues, and this is one of the things you hear from some gatekeepers, that, like, particularly around interoperability, or what I mean, like the alternative app stores, that would in a way bring risks to the users. And I mean, maybe the first thing to say is that we don't want we don't want a situation where the users are put at risk. This is not our policy objective. I mean, so if that were the case, or maybe put it differently, we are as concerned about, particularly, and when you know how the EU is, very proud of the GDPR and our fundamental rights framework. I mean, the last thing we would want to do is to put our users in a situation where actually their rights are less protected or even put at risk. So if gatekeepers make that point, and some do, we are all ears. And it's definitely also because we have a regulatory dialogue. So this is not like the EU sitting or the Commission sitting behind a desk and then whatever emails going back and forth. And so now we are trying to work towards a solution that actually opens up the market and creates these opportunities I've been talking about, but not kind of a solution that then would trigger new problems, for example, lower security or lower privacy. I mean, one of the proposals, or at least one of the provisions in the DMA, is interoperability between interpersonal messenger services that have been designated as a core platform service. So, like, for example, WhatsApp has been designated because it's got like more than 10,000 business users. I mean, 45 million users in the European Union. And of course, WhatsApp has security. It's encrypted, and it's one of the things that, like, Meta users, your communication is safe on our platform. So if a other party comes, and that's happening, saying, okay, but I want to be interoperable, I want to get to a situation where, like, my customers can send messages to WhatsApp users and WhatsApp users can send messages, so that it's a bit like what we have, which we take for granted with our phones. It doesn't matter whether you're on Verizon or AT&T or T-Mobile. I mean, I can call you even though I'm on the other provider. So that's the idea behind. But of course, what we don't want to get to a situation is where, like, people who are on WhatsApp suddenly, because of the interoperability, would have to accept that, like, for example, their encryption standards or their encryption is much lower than they are being offered by WhatsApp. So that is a technical issue. I mean, but we are sensitive to the argument because we, like the gatekeepers, that's not what we want. That's absolutely not the objective of the regulation. But what we do believe is that you can actually open up and make services interoperable, like these interpersonal messenger services, in full respect of the security and the privacy. So, and sometimes we have the impression that referring to like security and privacy is a little bit of an excuse to say, look, actually what we're saying is we don't want to do this. We want to keep the garden walled, and we don't want any opening in that garden. So we sit down, we talk, or not we, I mean the colleagues in Brussels sit down, we talk. We have a lot of experts as well, also from other companies. I mean, one of the things I think it's important to understand, because we sometimes look at this group of 7 gatekeepers as like very like homogeneous and like they're circling the wagons and like we're all on the same page. They're not. And so if one gatekeeper says, look, it's really, really risky for our privacy and security, other gatekeepers come to us and say, we don't believe that. That's not true, because here are some technical solutions that enable that gatekeeper perfectly to continue to ensure that there's a very high level of privacy and security, and also academia, etc. So these discussions tend to become very, very technical, as you talk about encryption and all kind of like technological standards, etc. But we have not been in a situation where the gatekeepers have pointed to like manifest risks to the privacy and security as a result of like interoperability. So, but we are mindful to this, and this it's not that the Commission has chosen just to open up and then après nous le déluge, let's see what happens. No, we are very kind of mindful of the fact that privacy and security in the European Union is tremendously important, but we think actually this is not necessarily a trade-off. You can have both.
Do either of you have any comments on that?
Yeah, I mean, I agree with all that. I think that these are serious concerns that need to be addressed seriously, but they also have to be seriously probed to ensure they're not pretextual, and they're also not unique arguments to DMA. I mean, we've seen here in the US, in the antitrust cases brought, for example, at the app stores, these frequently get raised. Oh, it's a security issue if I allow a payment outside my ecosystem on another website, despite that, you know, that's all highly regulated. So there's really not really much of a concern, and those haven't been obstacles to judgments in those cases. So I'd say it's not something unique to DMA. And there's a little bit of a crying wolf issue with it, I think. If gatekeepers continue to say this and it turns out to be pretextual, I don't think it helps them long term. It doesn't help their consumers long term either.
Maybe just saying, in antitrust, we have powers to ask for information to the companies or to complainants or third parties, so we get quite of a good picture of the reality of the arguments, and we also can search for internal documents. So we see the own documents of the company itself, and there we can indeed verify if there are really security concerns, and then we can work around those, or if those were a bit of a pretext, no? But obviously, I mean, we had the discussions with Microsoft on the Teams case, which we closed in September last year, and it was again about untying. So they had tied their communications tool Teams to their whole productivity suite. So competitors like Zoom or Slack, they don't get and they were telling us interoperability is critical, because if I cannot offer, I mean, if my product, Zoom, cannot interoperate with their Outlook or whatever in the same way, then this is not really leading to anything. So we could very openly discuss with Microsoft issues such as security and understand from their people and their documents how important that was.
So this one, I want all three of you to weigh in, but I want to start with Aaron on this from the platform side. One of the concerns that comes up in a lot of this, and this is sort of a global internet question that people are raising, as there's more internet regulations around the globe, you begin to get fears from some that we're losing what was once a sort of open global internet, and we're leading to, you know, different fragmented internet, different walled gardens with different approaches and different things being allowed. Even as you're, you know, happy with sort of the DMA and sort of what it's creating and the antitrust enforcement and what that is enabling, is there a concern that different places around the world? Is Europe going to have one internet with certain features and certain features not there, or certain things are going to develop only there or only in other certain places? And does that make things more difficult for you as well?
From my perspective, no. I mean, I think, the Brussels effect is real, and companies do often make changes that end up being worldwide for the benefit of all consumers. So you can see how DMA enforcement or antitrust enforcement in Europe can end up benefiting consumers everywhere. So that, like, even if you have an Android device, like, you can use AirDrop because there's been DMA enforcement in that area. So it's not something that I'm really concerned about. And I think that worldwide, as people develop their own regimes, perhaps they will look to the leader and model themselves after that. And right now, when you're talking about ex-ante enforcement, that's DMA. So when we see things in UK or Australia, they do tend to look like what we're already seeing out of Europe, with some modifications to fit the local market.
You want to weigh in?
Maybe just to speak a bit about from the antitrust perspective, and also thinking of the companies we go after, or mergers control, by the way, is the importance also of the coordination between the different jurisdictions. So one issue which is raised indeed is that if we are looking at a practice or at a merger, a transaction, which is taking place in several jurisdictions, the more there is consistency in the way we're going to target that, or the way we're going to solve that, the better actually for the company itself. So that's very important. We always talk to the companies, so they gave us waivers so we can speak with the other jurisdictions about how they see the issues. Of course, that might also be seen as a way for them to lose a bit on their possibility to push back and to defend themselves. But ultimately, if we are to go against against a certain practice, or to block a deal, or to allow it under certain conditions, they can benefit from the fact that there is a consistent approach. And sometimes there are a bit legal factual differences which justify a different approach. But the more we can also cooperate, the better for the company itself, because then it doesn't have to adjust its business everywhere. We don't want, as a principle, to ask Google or Microsoft to do things different only in Europe. So ideally, you would want to allow them to have a worldwide operation that is simpler for them. So you could speak about burden for them. So I think this cooperation is important, and often we do follow the same principles, and that's useful for them. And then obviously for the companies that then benefit from the outcome of such antitrust or merger intervention.
I'll just add one more thing, just based on what you said, if that's all right, too. I mean, I think some of the work that you see in the remedies in Europe will then get potentially adopted in the US, as there are more cases, not just by government entities, but also in civil litigation. It becomes harder as a company to say you can't do a particular behavioral remedy if it's already been done. So I think that's another area where it's very helpful.
I think in this area of economic policy regulation, I think the kind of the splinter net, or like the fragmentation of the internet, I think is less relevant. Of course, I mean, look at China and look at, like, I mean, yes, there we have already the internet that people have access to in China is very different from the internet that we have access to in Europe or the US, but that's like for different reasons. But it's sometimes useful to bear that in mind, particularly when the European Union is accused of like making it very hard to operate. I mean, all of the companies that we're talking about here are very present in the European Union. They're actually very successful in the European Union. I mean, our users love many of the products that we might have even difficulty doing without. So I think the point I want to make here is that from a market access point of view of like operating and like doing business in the European Union is a very good place to do business. I mean, some of these companies have actually more users in the European Union, higher margins, profit margins in the European Union, making more money in the European Union than they're making in this market. It is a normal principle of like, call this like international law or law in general, is that like if you operate in a particular market, you have to comply with the law of the land. And that's not just true for like internet economy, it's true in every area, like whether it's car manufacturing or it's pharmaceuticals or it's machinery, etc. I mean, don't even think about selling a car that is like legal in the European Union and just put it on the road here. It's simply, it's not accessible. So that's a fact of life for industry, that like if you operate in the European Union or you operate in the US or in Asia, you have to comply with rules which are not the same. And that's okay. Maybe sometimes it's a bit of like a frustration, but that's the way it is. And we are entitled, we have our sovereignty. The US has sovereignty to set the rules which we believe are fit for like our societies and our economies. Then talk about like the Brussels effect. I mean, I think it actually kind of more starts because we're all, at least from a regulatory and policy point of view, we're all looking at these issues because these are challenges there. I mean, when we were designing the DMA, of course, we were also talking with third countries, and the first thing you notice is they are thinking about the same questions. Maybe we were a little bit ahead in terms of finding answers to these questions, but any like competition authority around the world or policy authority around the world is thinking about like, what about digital markets? How can we make sure that like it brings the benefits and we mitigate the risks? In terms of like how companies then behave, I mean, in like GDPR, you often see that companies say, okay, now I'm not going to run two regimes. I'm not going to run like a regime for Europe and maybe some other parts of the world, and then a regime for the US, particularly not because California has also adopted like a 95% version of the GDPR. But if we look at the DMA, I mean, we can see at least very kind of the thing that are very tangible, we as users, I mean, the iOS, I mean, the access to alternative app stores is limited to the European Union. I mean, the interoperability between like a device and like an accessory device to that is limited to the European Union. So this is where companies decide, and it becomes then harder for them to say, because often they say, look, it cannot be done. It's not possible. It's technically too complicated, etc. And of course, if like lawmakers here see that actually doing it for the bloody Europeans, why can't they do it for the Americans here? But what we see with the DMA is, if you talk about the positives, say the benefits of the DMA in terms of market opening, these are limited to the European Union. They are not extended to like this country or countries around the world. And that's maybe one of the concerns that the businesses have is like, okay, we start with the European Union and then it will spread. Other countries are looking at the European Union, taking some inspiration from the European Union, maybe implementing some of the same measures. And then what we're now required to do, grudgingly, in the European Union will become like the way of doing business in most places around the world. So I think that's like one of the kind of the dimensions of the kind of discourse that we're definitely seeing. But in the DMA, we see that the benefits are, for the time being, are restricted to users in the European Union.
So one quick note that I'm sure some people bring up, with the car example, people point out that that's like the internet, is the fact that you have this sort of global communication network, which is different than like a physical product or a car. But we'll leave that aside. The next question I wanted to ask, and again, I wanted to kind of go across to all three of you, is this question of whether or not this is fighting the last war, right? This comes up a lot in sort of policy, especially in antitrust, and certainly was part of with the Google antitrust case in the US, where they went through this years-long process, and all these things happen. They finally get to the remedy stage, and the judge is like, well, you know, in between even the original finding of antitrust violations and the remedy point, you know, AI has completely upset the market. Does AI change all this? And is what is happening now with antitrust and with the DMA and with all of these approaches, is this, are we looking backwards instead of looking forward? And I know there's obviously other AI regulations that everyone's talking about. I kind of wanted to hear your perspective on that. Who wants to start?
I'm thinking of it. I think that's a very good question if you look at antitrust enforcement and how it works and the time it takes. So indeed, as Gerard explained, DMA was coming out of experience in antitrust, but also realizing that antitrust enforcement is complex and therefore can take time. So indeed, it is complex because first you need to define markets, and this is quite difficult in a sector like this one, which moves all the time, very quickly, and which are complex also product, and you need to establish a dominance, and for that you need a lot of data. You need to prove a capability of effects. You need, of course, to prove the conduct, etc. So that's the downside of antitrust, and where it was thought, okay, for certain types of companies who are gatekeepers and for certain practices and problems which are systemic, we set out clear do's and don'ts. That's the ex-ante rule. I mean, still I see room for antitrust. I mean, now we have a bit of experience, and we see now in the AI area that some of the usual suspects, which still have dominance in some markets, might use that dominance, that position to leverage, enter new markets. Think about Google. I don't want to always mention the same one, but it's clearly dominant in search. And with that dominance, they can now actually leverage that dominance in AI world. So we hope, and we have a lot of pressure to try to bring forward cases much quickly. And we might be able, because we could start from a point where we can say dominance is established in a market for search. At the same time, since I speak about search, it's clear that we're going to have to watch out how AI might actually change the search market. So search is already morphing into something where, apart from results, you have the AI overviews, AI modes. So search and AI-based search are becoming one. So that will be certainly a difficulty. But, and this is what we were saying yesterday in the conference where Joanna was, where I was speaking in concurrences, where there was this say, yeah, nothing has changed a lot. Is from an antitrust perspective, the practices that we see and the theories of harm we have to build are quite similar. For example, leverage. I'm dominant somewhere, and I use that dominance to reinforce my position or to conquer a new market. And that's why we have, for example, very recently opened proceedings against Google for not actually the creation of their AI overviews or AI mode, but the way they use content by publishers in general, not only news, but publishers in the search, potentially without paying or without possibility for them to opt out. That means in a situation where they exploit their customers and they also have access to an enormous amount of data in conditions that their AI developers, competitors cannot. Because even OpenAI, which is a big, important company, has developed the best AI model, cannot access all that data. So in a way, the practices and the theories of harm are the same. Maybe that's hope for an antitrust enforcement that goes faster. But that's why it's very important still to keep this parallelism and have the ex-ante that can intervene there where it's designated. And us will have to also take into account the complexity of AI potentially changing markets and transforming, therefore, what we have defined and how we establish this dominance. A bit technical, I hope I was clear, but that's how I see it.
Yeah, I think this example shows an interesting juxtaposition between DMA, where you can open an inquiry into Google over AI overviews, versus the Meta case that you were talking about, or Judge Meta, not Meta, the company, right. The government, the US government and states case against Google over general search, where Google was adjudicated to have engaged in an illegal monopoly in 2024. Yet when the remedies decision came down, at the core of this case was the $20 billion payment that Google makes annually to Apple to remain the default on Safari. And the court had adjudicated this to be an illegal anti-competitive activity. Yet in the remedies decided that Google could continue to pay Apple $20 billion, in part pointing to OpenAI and some other companies. And now it looks like, it hasn't been, I think, 6 months since that decision came out, and it already looks dated now that we see, Gemini 3 comes out, we see hypergrowth. We see this week the deal with Apple to have Gemini power their future products. So I think the dynamic nature of DMA really is an interesting juxtaposition to that. And we'll see. There undoubtedly will be an appeal. Google will appeal, I'm quite sure, the liability decision in that case, and we'll see if the state and federal government appeal the remedy decision. And then there will be follow-on cases. I mean, I'd be remiss if I didn't mention Yelp itself has a case against Google here in the Northern District of California federal court. We filed 2 years ago on the tail of that general search adjudication against Google, saying that they're leveraging general search to dominate local search. Exactly the behavior I was talking about they engaged in Europe, they also engage in here in the United States. And we've survived 2 Google motions to dismiss. The case is ongoing, but AI overviews are also a part of that case. And the judge has accepted as plausible our arguments, at least at the pleading stage, that the resulting zero-click searches from AI overviews, the fact that consumers just stay looking at the Google ecosystem and don't click on any third-party results can be cognizable harm to Yelp and presumably others like us. So it is an interesting way to look at how the court cases differ from the inquiries, where you can, maybe perhaps more dynamically open an investigation and inquiry based on what you're seeing in the marketplace.
Maybe take a little bit of distance. I mean, I think what the DMA is also setting out is a vision for how we think business should operate in the European Union. It's like a model. It's about almost like we drive on the right side in Europe, and some other countries drive on the left side. So, but if you want to drive in Europe, you have to drive on the right side. And so all those who are now thinking about with new business models and AI and whatever comes, they need to bear this in mind. Maybe not directly, they might not be designated as a DMA, but it says something about what we think is the right way, or at least what is the preferred way in the European Union. So we like interoperability. We don't like self-preferencing. We kind of So I think it sets a direction that hopefully companies will think about when they innovate and they develop their new business models. The same with the GDPR. If you want to do a business model in the European Union, think about data protection. So that, I think it actually helps in a way structuring the market going in the right direction. What we have now with the DMA is there's this meeting between what we think our business, particularly in this area of digital, should look like and what business actually looks like. And so that then creates a bit of tension that we see. So there's business models that have been very successful, have allowed companies to grow and make a lot of money in the process. These business models are now in the European Union, at least for some of the aspects, are no longer in tune, are not allowed. And so that, I mean, I fully understand if you're on the side of the business that's uncomfortable. And we are now in this period. I mean, just don't forget that the DMA hasn't been around, at least not in effect it's been less than 2 years. So we're still in very initial stages. And so we're also testing a bit, and also from the regulator's perspective. I mean, I'm not saying it's little finding a bit our way in it, but in effect it is. And some cases might be litigated and there'll be jurisprudence, etc. But looking more ahead to the future, I think we can actually, companies will need to take this into account, how your rules for doing business, how that should be taken into account when you want to roll out your business model in the European Union. And then in general, I mean, it's almost like the 10 Commandments. No, you shall not steal, or what I shall not steal. I mean, you shall not self-preference in the European Union. We just don't like that. I mean, technology might evolve and there might be very different new technologies, but that principle, and also for AI, I mean, you can use it also to self-preference. We have actually, in some of the kind of devices, the Alexas, etc., that is there a risk of with AI that you can kind of direct customers to only one of the marketplaces rather than to another marketplace? So I think that the regulators will be open-minded, or at least be looking at these issues. So those principles are in a way immutable. I mean, we don't suddenly now think, oh, there's new technology, so self-preferencing, why not? And so that, I think, is an important consideration as well. So over time, I think we will see a little bit more stability in all of this. It's I think we're all finding a bit our way. What we want to get to a situation is where enforcement might no longer be necessary. I mean, there'll be always some, and so this is almost like a dream, we don't need to enforce anymore, but where companies also, because of upstream, so we want to have a regulatory dialogue, not when the problem is on the table, but when companies are still in an earlier phase. And if we have a healthy relationship and regulatory dialogue where there's some trust between the parties, we might actually be able to head off a number of these issues by kind of giving some guidance here and there. So that's a way. My hope is that those who are now developing new business models will think about the DMA and what are the principles that the European Union has put in place for models of the past, but these will also apply to models in the future. And then with a kind of cooperative relationship, not just with the gatekeepers, but of course with the ecosystem around, to try to head off that problems that kind of once they get to the enforcement stage. I mean, in a way, we all lose. I mean, it's already late. I mean, we should try to catch these issues at an upstream stage.
So I've realized I've gone through maybe 5% of all the questions I had, but I think we also wanted to get some questions from the audience or from online. I don't know if anything has come in online, or if anyone in the audience has questions, or I'm happy to dig into my big list of questions too. Do we see any hands? What a shy audience. All right. Is that someone standing up? Is that you have a question, or are you leaving?
Going to the
Leaving.
bathroom.
Okay. And nothing online yet? Okay. Oh, wait, we do have a hand. Oh, you want to give the microphone over?
If I may, sir, EU, a broad footprint, technologies, regulation, also worldwide contact. EU's increasing involvement with South America, Mercosur, and so forth, how will that affect the process downstream? We're looking for a broader market envelope. You have EU and you have the world surrounding EU, and the distinction between the two seems to be more and more blurred.
So, yeah, so can we clarify the question a little bit? So is it that you're, yeah,
DMA, DSA, major thresholds,
Yes.
EU's continuing contact with the larger world. Do you see what do you see 5 years hence?
in terms of global or within the EU? Because you sort of had the Latin America.
Is there a nexus there that we need to be aware of?
A nexus in
terms of EU dealing with the larger world.
In terms of, do you think that EU like leading the rest of the world? Like, do you think
Yes.
like Latin America will they follow
Yes.
the path led by the EU? Is that so?
That is a good opening right there. Please.
Okay.
I wasn't clear enough, but that's the opening I'm looking for.
Okay. So yeah, how do you think that?
Yeah, I can say the world is, of course, watching what the EU is doing. I mean, there's no surprise. We are a little bit ahead of everybody else. We started looking into these issues before others looked into these issues, and we've also a little bit more experience, maybe, and we know a bit about how to develop rules and to negotiate rules. So I think first is, I mean, people will want to see how this is going to pan out. So what's going to be the effect of the European regulations? And that's smart. I mean, just wait. I mean, if the EU is going to make a mess of it, why would you want to imitate the EU? I mean, just wait and see. And so if it's a success, okay, then it's a good source of inspiration. If it's I mean, not producing anything or producing negative effects, like because of the trade-offs, and I mean, other countries will probably want to avoid following into the EU footsteps. So I think a lot of countries are looking at what's the effects, what's the benefits, kind of. I mean, and then almost inevitably, I mean, people will also, I mean, if there are certain things that benefits that the European Union kind of users have. I mean, you take the app stores, for example. I mean, if you download an app here from the App Store, I mean, typically Apple takes a 30% charge. So if you take a New York Times subscription through the App Store, I mean, every month after month, or a Spotify subscription, Apple takes 30%. Well, in the European Union, we have now competing app stores. You can also kind of download the app or conclude the contract directly with the provider, like through the Spotify website. So that means that Apple is not going to be able to charge 30%. So if you look at that, we are paying less for services than the average American will pay for the same services. Well, if the average American would know that, then presumably there would be a little bit of pressure, like particularly because these companies are all, I mean, based here. I mean, they're like American companies. Why can't these American companies give all of these benefits to the bloody Europeans that they're denying to like people living in this country or in other parts of the world? So if it brings benefits that are very tangible, where people feel they're being denied, I mean, for example, app developers in the European Union, they don't need to go to the App Store. they can go to any other app store, and then, of course, with some communication, they can just convince the user that it's better to go to that competing app store and download it, because, again, maybe of the 30% cut that Apple takes, which maybe another app store is only 10 or 15%. So there's likely, if it's a success, there's likely going to be forces in society saying, look, we want this too. And then, of course, we will need to see that that's not our responsibility, where, it's already difficult enough to make policy for the European Union. Where if we have to make policy for other countries around the world, it becomes even more complex. So we'll have to see. One thing that we always communicate to third countries is don't underestimate the enforcement capacity that you need. This is like, you look at DMA and DSA, we have 300 people working on the DSA enforcement side. We have like 75 people plus working on the DMA enforcement side. So if you are like a country in Latin America, it's not enough. The easy thing is actually kind of basically copy and paste what the European Union has done. Maybe you don't even have to translate it. European languages are also the languages in Latin America. But then to make sure that it is enforced. And then, of course, there is also, these are companies which are quite powerful. No, they're not like small companies. They will kind of push back. And so that's also like for the European Union, we have an important market behind us. So it's like we can kind of stand up if necessary to these companies, although we prefer a constructive relationship and everything else. We're not into it for conflict. On the contrary, we want to kind of see results and work constructively, respectfully with these companies. But if you're a smaller country, it might be a little bit more difficult, as we also know from experience. It's in maybe other areas, or at least in adjacent areas. So I think countries will continue to watch what the European Union is doing, and then they will decide whether they want to follow. And some are, some have, and others are. Like South Korea has a legislation before the parliament, which is quite similar to the DMA. Japan has also implemented already at least some of the provisions of the DMA. So we will see. We don't control that, and it's none of our business actually what third countries are doing.
Do you want to?
I'll just make one point just really quickly. There's been conversation about the ongoing dialogue between regulators and enforcers around the world, but it's important to note, as you said, it's been referred to that these are American companies, but really they're multinational, and they get to operate with a central command. So if Australia, for example, is considering its own ex-ante regulation, Google has a playbook, and it will, or whichever company will come in, and they already know how they're going to address it because they've dealt with this in different countries around the world. Whereas the local legislators or regulators, enforcers do need to have these conversations and dialogues to be able to understand how to approach it. And then it becomes even more complex for the local rivals, who certainly almost always don't have experience dealing with this. And that's, I think, where you see the gatekeepers have a real advantage, because they have this central command where it's really fragmented then on the local level, because you're going to have different competitors in every country, in every space. And I don't think that can be discounted.
So I think as a sort of final wrap-up question, I'd love to go down the row and just find out if we go 5 years into the future and we look, and you want to say that this approach has been a success or not, what metric are you looking at? Whether qualitative, quantitative, doesn't matter. What are you going to say 5 years from now, the European approach to handling regulation of these companies was successful or not? How are you measuring that?
Well, we will, we have recently done a study on trying to measure the impact of the remedies and the decisions we have adopted in antitrust, in the antitrust and the merger area in across all sectors, and also including the digital. And for that to look, and to look at the effectiveness of the remedies we impose, to try to see if that brings more competition. And then we look ideally to quantitative data that shows the level of prices, the level of players, the level of products and dynamism. And you also look a bit at qualitative, so you ask a bit people what are their views. I think for us, I mean, it's not easy because there are markets where you have already very, very big players. And we haven't spoken, for example, about cloud, where you have three very big players that provide a lot of services to many companies. And we have, for example, in Europe, a variety of other European players, smaller, medium companies that provide other type of services. And I was once asked, is our dream in competition that we try to bring the smaller up to the level of the big ones? And is that a race that we have completely lost in Europe? Or is it about ensuring that these three big players are behaving in a way that they still leave a bit of space below? And I think it's a good question. I'm not sure I have the answer. But I mean, for sure, we need to make sure that markets are opening up and that you don't have just a few that are reaping up all the benefits, and that for consumers to have more variety and more products and more quality, that you have a number of players there with a variety of products that can allow each to choose.
Yeah, it's difficult, but I think you want to be able to see in 5 years a more level playing field, more competition. In our narrow space, talking about self-preferencing in search, for us, it seems a little easier. We want those platforms with quality content to get more visits, more traffic. And we know which have more quality according to Google, because Google has an organic algorithm that it uses to rank content. So, we have been pitching for years our solution called Focus on the User. There's a website, focusonthe-user.com, which just shows that, hey, a simple way to get past this would be, instead of self-preferencing, just rank it through your organic algorithm, and you can have the same modules with the maps and the places, but just have it powered by whoever wins the qualitative assessment that you're already doing. So for us, it seems a little more straightforward, but definitely on the wider level, increased competition, more level playing field, and then allowing, the higher quality winners to win.
Mike, 5 years. 5 years. We have to demonstrate benefits much more quickly. I mean, people don't want to wait 5 years. And I think the good thing about the DMA, and also Joanna's example, I mean, we already can see the benefits. We can point to the benefits. I mean, we as users have much more control. We can set our own choice screens. I mean, we can port our own data. We have access to alternative app stores. I mean, we kind of have more choice. And so, I mean, how do we define success? And not just 5 years from now, already now. We have to kind of keep our ambitions high and demonstrate in general. I mean, in Europe, we have to demonstrate that the European Union is a force for good, that it brings benefits to people. We don't have 5 years to do that. That the user experience on the internet gets better. You have more choice. You are more in control. It is more affordable. That's like the test. And I think we're already kind of seeing evidence of that, but there's more to come. On the business side, more opportunities. So you have more opportunities to reach your customers, to provide better quality service to your customers, because you have, again, more. I mean, just an example. You're on Amazon. Before, it was very hard to get the data of like how people are using the Amazon marketplace. How much time were they spending on your products, and where did they go from your products to some? So if you're in the App Store and you're like Times or Spotify, even know who your customers are, because you have a contract with Apple. You don't have a contract with the New York Times. So if you're New York Times, you don't know who the paid subscriber. This is all changing. So now, if you're New York Times, not so relevant in the European context, but if you're Le Monde, you can provide specific offers. You can reach out. You can test what people are most interested in. You can optimize your news or your kind of entertainment, etc. So those are all kind of opportunities that the DMA will make possible, or is making possible, that weren't possible before. And of course, what we also want, challengers coming in that like dislodge. I mean, take away some of the market share, come with totally new business models and all of that. So that's how we should define success, but not 5. I mean, 5 years from now, it's 2031. I mean, that we can't work 5 years. It's now, it's next year, and so we need to make it work.
Okay. I think on that note, we're going to wrap up. So I don't know if you had any final words, but thank you to the panel, and everyone can clap. Give them a round of applause.